That's the message. Wait a minute. We have to wait for her to get back. Yeah.
Let's let the room settle for a moment, shall we? You may proceed.
Thank you, Mr. Chief Justice, and may it please the Court. I would like to reserve 5 minutes for rebuttal, and I'll gladly waive the free fire zone. I'll take questions from the Court at any point. There are many questions in this case. I should introduce co-counsel Imran Syed and Caitlin Plummer, both from the Michigan Innocence Clinic at the University of Michigan Law School. We're here today, and indeed Ms. Swain herself is here today, because Judge Sent made a series...
Counsel, good afternoon. I'm so sorry to interrupt. We just need you to state your name for the record.
I didn't. I'm sorry. I'm David Moran.
Thank you, Counsel.
Introduced co-counsel, failed to introduce myself. We're here today because Judge Sent in Calhoun County, after hearing the trial of this case and then hearing the evidentiary hearings after the case on the post-conviction motion, made a series of key findings. And those key findings were that Detective Pickett had a conversation with Dennis Book, who was the only other adult in the house for most of the period during which Ronnie Swain alleged that there was sexual abuse occurring every weekday, that Detective Pickett was told by Mr. Book in no uncertain terms that this abuse had not happened, and that had it been happening, he would have turned her in himself, and that no report was made of this, and the defense was not advised of this.
Okay. Can I ask you to describe for me what you believe is the newly discovered evidence?
The newly discovered evidence is the fact that the conversation between Detective Pickett and Mr. Book occurred.
Just the fact of the conversation, not the willingness of Book to testify he observed while he was living with the defendant no sexual abuse.
What that derives from it, Your Honor, and that's a key point of Brady law, is that Brady evidence is evidence that is withheld by the prosecution. And in fact, I believe in the great majority of cases, the Brady evidence consists of a report, or as in this case, a verbal recollection, not actually reduced to writing. And so that report is usually not admissible, but what comes from that is admissible evidence.
All right.
So wait a minute. It's not just the fact of the conversation. It's the fact that the conversation took place plus the contents of the conversation.
Correct. I'm sorry. Yes, it's the fact plus the contents. So as far back as 1960.
Okay. That may be a Brady formulation, but I'm trying to figure out why, if newly discovered evidence is this standard for a successive post-judgment motion, why knowledge of Book's awareness of what was going on in the trailer where he lived was newly discovered as to the defendant. Because, let me just finish, she had two live-in lovers, and I forget the name of the one she called, but he testified consistently with the way Book in his affidavit said he would testify. He lived there, he was there in the mornings, and he saw no sexual abuse by the defendant of her son, right?
That's not quite correct, Your Honor.
He did testify that way.
He testified that he was there, but then on cross-examination he revealed that he wasn't there when the children caught the bus. He left early, so his testimony was worse than useless. It was actually harmful to the defense.
All right, I understand.
Yes.
But I'm trying to understand how it is that a live-in lover who was there during the mornings was newly discovered as to the defendant. It would be like me saying about my live-in wife, I didn't know that she had evidence about what was going on in my household.
Well, it's important to make it clear, Your Honor, that this is a Brady claim,
I know.
not a Crest claim.
I'm trying to separate out.
Right.
I believe you may have a Brady claim, but I don't believe you have a claim within the meaning of our newly discovered evidence rule.
And that's why we didn't plead it as such. It's been pled all along as a Brady claim. In fact, it was remanded by the Court of Appeals after the first round for development of the Brady claim. Now, the
Do you understand? The premise of my question is, you may have a Brady claim, which an Article III court judge is obligated to parse. I'm suggesting to you that the Michigan has a right to have rule of finality that may even cut off a constitutional claim. And unless that Brady violation is in fact newly discovered evidence within the meaning of our jurisprudence, defendant's remedy may be in that habeas case that's already filed.
Your Honor,
that's what I'm trying to understand.
I get that, Your Honor, but if that's what this court did in 6502G, it doesn't read that way. 6502G is not consistent with the Crest test. If this court meant to simply impose
okay, let's take Crest out of the... Let's say the Court of Appeals erred in imposing a diligence requirement. I'm still hard-pressed to understand within our jurisprudence how the defendant who lived with this man didn't understand he was a witness and could testify about what did or didn't happen in the trailer.
Your Honor, what we have shown through the testimony here is that they tried to get Mr. Book. Ms. Swain called Mr. Book.
All the better.
Ms. Swain,
because that means she was aware that he could give the testimony. His unavailability doesn't make his testimony newly discovered, and as I understand our case law.
But I have to argue with the
unavailability.
I have to argue with the premise of the question is that this is not a newly discovered evidence claim. This is a claim of a newly discovered Brady claim. It's not a newly discovered evidence claim, which is a non-constitutional claim.
Okay, I understand.
Yes.
My question is premised, however. If my construction of the court rule is that your only avenue of relief under our rule is that you're able to posit newly discovered evidence, I don't understand, and I understand you may not, you have a different construction of the two provisions, but if that's my construction, how do you establish newly discovered evidence?
I believe we would meet it even under that test, but I have to vigorously disagree that that's what the court rule says.
I understand, but I want you to at least answer, can you
Sure.
make the
Sure.
newly discovered evidence threshold apart from the Brady?
Because nobody knew what Dennis Book would testify to, because he wasn't communicating. He would not, Ms. Swain's father, Mr. Johnson, went to try and see him, and Mr. Book testified that basically he slammed the door in his face. He threw away Ms. Swain's letters. He hung up on her phone calls. And so what Mr. Book would testify to was unknown, and that was not discovered until 2011 when we discovered that actually he'd had a conversation with Mr. Detective Picketts and told him in no uncertain terms, basically, I detest this woman, but she was not sexually abusing these children every day. At that point, he becomes the best possible defense witness, the witness who dislikes intensely the defendant, but nonetheless would have come in, if subpoenaed, and said it didn't happen. Now, the prosecution has suggested that somehow Ms. Swain had a duty to subpoena him anyway. That's per se ineffective assistance of counsel. That would be, frankly, crazy, Your Honor, to subpoena a witness who you have every reason to believe is going to try to hurt you. But the statement changes that calculus.
Why don't you subpoena the witness and then see what you can get from the witness before calling the witness?
But you couldn't get anything from the witness because Mr. Book made it clear he wasn't talking to Ms. Swain. He wasn't going to talk to anybody on her side. And even worse, that would bring him down to the courthouse. So if he is damaging, then the prosecution is going to have him right there.
Does that the defendant say, I live with this person, he was there all the time, he should testify that it's not possible for this scenario to have occurred?
That's why they tried to get him. And so if there was a diligence standard here, which we firmly believe there's not, they met it. They tried to get him, but he wouldn't cooperate.
Right, but that doesn't make his evidence newly discovered.
But what is newly discovered, Your Honor, is that, in fact, he'd had a conversation with the detective in charge of the case. The detective in charge of the case, if you look at 31A of the appendix, knew that Mr. Book was the only other adult living in the house for most of the relevant time period. So it makes perfect sense that he would call Mr. Book. And Mr. Book told him, in no uncertain terms, it didn't happen. Now, the problem...
What if we think of, let me see if this works. If we think of 6502G as relating to types of claims that you can bring. So you can bring categories of claims. You can bring claims on new law, and you can bring claims based on new facts. And encompassed within the claims based on new facts are at least two kinds of claims: Brady claims, all Brady claims,
Yes.
and newly discovered evidence claims. Those are subject to Cress.
Yes.
And so you get over 6502G simply by bringing a Brady claim, and then you've got to prove your Brady claim, which is not easy.
We would have to prove first that the...
Doesn't that get you over the Chief Justice's
Yes.
problem?
It does, because what we have to show is that the evidence of the Brady claim, which is the discovery of what book said to Pickett's, was discovered after the filing of the previous 6500 motion, which it was. It was discovered in early 2011, and the previous 6500 motion had been filed years before. So what we did was we supplemented this to the existing 2009 6500 motion that we filed on behalf of Ms. Swain.
Well, now, why wouldn't that, so let's say you like my formulation, but why won't that open the floodgates to all sorts of claims of people saying, I just didn't want to call my live-in lover. I just didn't want to call him, and so I didn't. And so, but now I'd like another bite at the apple. Why wouldn't that be a problem?
Because once we get past 6502G, we then have to satisfy 6508D. And 6508D has a diligence requirement. So there we have to show that there is good cause, either diligence, couldn't with diligence have found this evidence before, or if it could have been found before, there's good cause for not doing so, or, very importantly for a case like this, the judge finds that there is a significant possibility of innocence. And so for the defendant like Ms. Swain, for whom there is a significant possibility of evidence, in fact, Judge Sent has now found that he has, quote, no doubt that she satisfies the standard for actual innocence. This is a way that you can bring a new claim, and if there is any gap in the diligence here, then the judge can still hear it, because I think many members of this court have said before that a defendant who has strong evidence of new innocence should always get that evidence in. There should not be a bar at the courthouse door.
But what if I'm kind of stingy on that? So I don't really want to go that way. How can I still rule for your client? So if I don't want to go to actual innocence, how can I still rule for your client?
Well, you can rule for my client because she meets the requirements of 6508D3 as well, because she was diligent in trying to develop this evidence back at the time of trial. She could not have gotten it before 2011 when Mr. Book finally decided to come forward. And therefore, so first of all, you don't even get to the good cause, because the showing that you have to make to avoid even showing good cause is that you couldn't have developed this evidence before the filing of the previous motion. And so it's in our position all along that that's met. If there's any doubt about that, well, there's good cause for her not meeting it, namely, again, Mr. Book's reticence to talk to anybody. And then again, finally, if there's problems with the good cause requirement, Judge Sent's finding of actual innocence, to which this court should owe deference, also gets around the 6508D3. So taken together, 6502G and 6508D3 prevent the floodgates problem. Because while somebody can claim that I've got new evidence of a Brady violation or some other constitutional violation or just new evidence supporting a Crest claim, they still have to get past 6508D. And if they haven't been diligent and don't have strong evidence of their innocence, then they won't get past 6508D3. So 6508D3 is the backstop for the person who basically is sandbagging. There's no sandbagging here. And turning to the substance of the Brady claim, the arguments that have been made by the prosecution and the Attorney General and their amici would basically overrule Brady itself, because Brady was in a very similar position to Ms. Swain. There was a witness that Brady knew could exculpate him, namely the co-defendant. He knew that the co-defendant was the one who had actually strangled the victim, and it wasn't Brady. Now, this is for purposes of death versus life in prison. And under the prosecution's theory, then, Brady would have been somehow negligent in not calling Mr. Boblet, the co-defendant, or subpoenaing him when you would fully expect that you're going to get damaging testimony. Same thing in Tavera, United States versus Tavera, Sixth Circuit case upon which this court recently relied in finding that there's no diligence requirement under Brady in the Cheneau case. In Tavera was a passenger in a car that was full of drugs. The driver, with Mr. Mendoza, it turns out, told the prosecution before Tavera's trial that Mendoza didn't know about the drugs in the car, which was exactly Mendoza's defense. That information wasn't turned over to Mr. Tavera. So again, under their theory, it's Mr. Tavera's fault for not subpoenaing Mr. Mendoza, getting him to the courthouse, and discovering that way that what Mr. Tavera already knew, which is Mr. Tavera didn't know about the drugs. And of course, the Sixth Circuit completely rejects any such argument that he has such a duty to call who's going to be an unremittingly hostile witness. If I can give one more.
Can I just, before you do, can I just follow up on what the Chief Justice asked you a few
Yes.
minutes ago? Is it a claim of new evidence, to put that term together, is it a claim of new evidence that the defendant here has alleged a Brady claim that's based upon new evidence of a Brady violation?
Correct.
Explain that to me again.
So in 2011, we discovered Dennis' book.
I understand the history, but I'm really asking a textualist question here more than anything else, whether it can be fairly said that there is a claim of new evidence where all that's happened is that a Brady claim that's based on new evidence of a Brady violation has been asserted.
That's it, yes, and that is our position, that the 6502G requires that the claim be based on a claim of new evidence. And the new evidence that we claim here is the discovery that Mr. Book had this conversation with Detective Pickett's around the time or shortly before Ms. Swain's trial, in which he told her in no uncertain terms that the abuse did not happen.
And can I ask you, are there two classes of Brady violations? One, the most traditional class of Brady violations where the prosecutor affirmatively withholds exculpatory information. And secondly, the new class of Brady, I'll call it the new class of Brady material addressed in the Chenault case, in which the material is held by the prosecutor, but it was also readily available to the defendant, but the defendant simply didn't go through whatever procedures were necessary to identify it. We've said in the Chenault case that the second class of information fits within the class of Brady materials, but are both of those identical for purposes of us analyzing 6.502 and 6.508?
I do, Your Honor, but I think this is actually a very traditional Brady case. As the Sixth Circuit recently said in Tavera, the case I was just talking about, it's not unusual for prosecutors, and you can substitute in prosecutors or police, to receive exculpatory statements the defendant does not know about. That's your standard Brady claim, and that's exactly what this case is. This is a standard Brady claim where the police talk to a witness, the witness tells the police or prosecution something that is highly exculpatory for the defendant. That's not turned over, and as a result, the defendant does not use it. Typically, the way they would use it is by calling the witness.
So you don't see this as a Chenault/Brady violation?
Chenault is relevant only to the extent that it goes to the question of, was there diligence in not finding out about what Mr. Book knew? But the diligence here, I can't imagine what the diligence would be that would find out about the conversation that is the basis of the Brady claim that Judge Sent accepted here. And if I might,
even if we thought there could be something that she could have done, that she doesn't have a diligence duty under
No.
this court's decision in Chenault. So
No.
whether she could have done something or couldn't have done something, this court in 2014, rightly or wrongly, did away with the defense diligence requirement.
that's right. So I don't think the diligence is in play here, except as one of the three ways that Ms. Swain could satisfy 6508D. So we do argue that she was diligent as one of the ways that she satisfies 6508D, because that explains why this claim couldn't have been found before 2009. I promised I was going to mention one more U.S. Supreme Court case, and that's Kiles v. Whitley in 1995. There, the prosecution withheld many statements from the informant, who's called throughout the opinion Beanie. I'm not even sure of his real name. Many statements that Beanie had made that led the police to arrest Mr. Kiles in the first place. Beanie was an informant who essentially said, Kiles is your man who committed this murder. And the police and prosecution withheld some of the first statements that Beanie made, which were highly inconsistent with some of the evidence that the prosecution presented. But Beeney didn't testify at the trial. And what Justice Souter, writing for the court, says in Kyle's is that had this evidence been turned over, one of the things that Kyle's attorney could have done and likely would have done would have been to call Beeney as a witness in order to get in his statements, which would have then demolished large parts of the prosecution's
But we didn't know who the mysterious Beeney was, right? Nobody knew who, there was this alleged Beeney, and he had talked to the police, but we didn't really know where Beeney was and how to get to Beeney.
I think Kyle's knew who Beeney was. I believe the record indicates, the opinion indicates in Kyle's, that Kyle's knew who Beeney was, but the decision was made, I assume, by defense counsel not to call Beeney. It would be the normal decision is you're not going to call the guy who's blaming your client unless you know that he's made statements that actually are extremely helpful for your client. And so that's the same situation here. In Kyle's, Justice Souter, writing for the court, says, had the defense known this, the first and most obvious thing they could have done with Beeney is call him as an adverse witness. And that wasn't done. He would have obviously been a hostile witness. As it turns out, in this case, Mr. Book, I assume, would have been hostile because, as he indicated, he still bore a lot of hostility to Ms. Swain because of the nasty nature of their breakup. But he would have testified, he confirmed he would have testified to the truth that absolutely these allegations of sexual abuse occurring every morning before the kids went out to catch the school bus were simply false. Now, there's a lot of other evidence in this case that has been developed since the time of trial, but Judge Sent found that just this evidence standing alone was more than enough to grant a new trial, and which is, of course, all we're asking for. We're not asking for an exoneration or a certificate from the governor. We're asking for a new trial at which this...
I'm sorry, can I ask about the standard of review here?
Sure.
So there seem to be some cases that say that the standard of review for a Brady claim is de novo. But then we have case law that says standard of review on a 6500 motion is abuse of discretion. What do I do with that?
Frankly, Your Honor, I don't know. And I've puzzled about this myself. But let me give you my best shot at it. So there are findings that Judge Sent made here that are subsidiary to the ultimate decision. So the judge made findings of fact. He found that the conversation between Detective Pickett's and Mr. Book occurred. That is a finding of fact. That is subject to clear error. He made credibility determinations, which, as I read this court's precedents, are subject to clear error plus heightened deference. Mm-hmm. Any legal determinations he made are obviously subject to de novo review. So a legal determination as to what is Brady, is there a diligence requirement, for example, after Cheneau? That would obviously be subject to de novo review. But the ultimate weighing at the end of would this evidence make a difference? Not clear, but I believe that has to be reviewed for abuse of discretion, consistent with this court's precedents. I know Chief Justice Young, in your dissent in Trachtenberg, you dropped a footnote saying that the ultimate decision on whether to grant or deny a new trial in a 6500 context is for abuse of discretion. And I think that makes sense because this is a weighing that is done by the trial court, who frankly is in a far better position than any appellate judge can be to examine. Sorry.
The only exception is if the judge is making a legal determination about what this evidence is.
Yes.
And I'm still stuck on, is this in a conventional sense, not the Brady sense, but a conventional sense, newly discovered? So, I mean, if he made that determination, if it's a Brady violation, to me, that doesn't answer the question whether under our rule this is newly discovered evidence.
Well, I think at worst, the 6502G rule is unclear. But I can't believe that this court drafted the rule so as to exclude Brady claims. In other words, that if a Brady claim does not surface until after the defendant has filed a first 6500 motion, that defendant is out of luck and has to go to federal court.
Why would you postulate that when it's quite clear that the United States Supreme Court has indicated that the states may create rules that exclude, after conviction, serial challenges to a conviction. We have a right to insist on finality, and our rule for creating finality is a important state interest. So I'm not sure why there is an identity between a constitutional violation that is discovered after our finality rule has come into play, particularly since there is a remedy still available. It's just a habeas remedy.
But, Your Honor, I think it would be curious if this court were to have written a rule with the intent to say...
Not with an intent. The effect of the rule is that a Brady violation is a Brady violation, but unless the evidence that is the genesis for the Brady violation is newly discovered evidence within our jurisprudence, it's a Brady violation, but not a key into a successive motion.
May I answer that and then reserve the rest of my time for rebuttal? I still think it would be curious because what it would do is reward the government for withholding evidence until after a defendant has filed a first 6500, while allowing somebody to proceed with a Crest claim, a pure Crest claim, no Brady violation, no matter when they discover it. And it seems that a Crest claim is, in the general course of things, a lesser concern, a lesser claim than a Brady claim. And so I would just be surprised if that was the court's intent in adopting that particular language in 6502. Thank you, Your Honor.
May it please the court. My name is Jennifer Clark, Assistant Prosecuting Attorney for Calhoun County, representing the people, Plaintiff Appellee. Seated at my counsel table to the left is the Solicitor General, Aaron Lindstrom. I have ceded 10 minutes of my time to the Solicitor General and will be presenting for 20.
Would you speak up, please?
Certainly. The presumption of innocence evaporates with the jury's verdict. But our state allows defendants the right to an appeal, effective assistance during that time, and still we allow for the possibility that a defendant might be entitled to relief from judgment. Thus, this court drafted the exclusive procedure for allowing a person with newly discovered evidence to present that claim to the court at any point in time, regardless of whether they have filed a post-conviction motion previously or not. But here, the simple fact of the matter was the defendant was not entitled to relief from judgment because the evidence was not newly discovered. The evidence was also not material. There was no Brady violation. Dennis Book was undisputably a known witness who was not called at the time of trial for strategic reasons. In the 14 years since trial, during which the victim explained that he recanted because he was under pressure to do so.
Counsel, it really is, you need to speak louder.
You can put the podium up higher too if that's helpful.
Thank you.
Is that better? No.
As long as you keep your voice
Okay.
up, it will be.
Thank you. I apologize. In the 14 years since the time of trial, we have had 2 motions for new trial. A Ginther hearing, during which time the trial attorney stated in reference to letters that the victim and his brother wrote that there was some coaching and encouragement that created them. The family said they talked the boys into it. I took that into consideration. Moreover, we have had 3 motions for relief from judgment. We are well beyond the time of the direct appeal at this point in time, and the jury's verdict is entitled to respect. This court crafted the procedure in 6.500 as the exclusive means for defendants such as this one to seek relief in post-appeal. The procedure requires in a successive motion that the defendant have newly discovered evidence. As we have understood that term for years, back to the end of the 19th century, to be the current Crest test. Clarifying that the well-established test for newly discovered evidence applies to claims purporting to raise newly discovered evidence in a 6.502G motion serves the intent of the court rules, which was to end serial motions for new trial and preserve finality. While it simultaneously encourages diligent, effective representation, ensuring the trial remains the main event for determining guilt or innocence. Were a defendant presenting a newly discovered evidence claim in a motion for new trial in conjunction with a direct appeal, as was the case in People v. Rao, must exercise reasonable diligence. It cannot reasonably be considered overly onerous for a defendant in a collateral proceeding to do so as well. A witness who is known to the defense, whether correctly or mistakenly believed to be hostile, cannot be considered newly discovered. The defendant knew who Dennis Book was. She knew where he lived. Her father went and spoke to him. But trial counsel said at the evidentiary hearing, even if he knew that the alleged conversation occurred between Book and Detective Pickett's, he still might not have called him for strategic reasons, because to do so would have undermined the other witnesses that were presented and would not necessarily have supported the defense. Therefore, when making a decision between the evidence and strategy, the defense chose strategy. Furthermore, the evidence was not material. Anything Dennis Book had to say would have contradicted testimony that was presented and only would have covered one small portion of time, not the entire time period, which occurred at 2 different locations. He could not speak to what happened at the second crime scene. Therefore, it was not material. Furthermore, although not necessary, there was evidence in corroboration of the victim's testimony. The disparate treatment the victim and his brother received, they both spoke to. The victim was treated as a boyfriend. His brother was not.
Counsel, I'm interested in something you just said. How would Book's testimony have contradicted defense testimony that was presented?
Because the defendant said that their relationship started later than what Dennis Book did, and Stephen Way was living there at that time, and therefore it would have conflicted. The timelines didn't line up.
Okay, so it's the timeline that's the only thing.
That's the main thing, yes.
Okay.
Yes.
But isn't it significant now that it won't contradict any longer?
It would still be contrary to the testimony that was presented.
But it
Absolutely.
wouldn't be inconsistent with the testimony, arguably, that would be presented at a new trial, though.
It would be cumulative to the type of evidence that Steve Way testified. Contrary to what was represented, Steve Way actually testified that he was there in the mornings, his work schedule varied, and he was unemployed during this period of time. Therefore, he could have testified. So at the most, Dennis Book would have offered cumulative type of evidence.
It strikes me you are making more arguments than are necessary here. I do not understand why testimony that is corroborative of the defendant's position that she didn't molest her children is immaterial. That's the argument you just made. Now, it may be that trial counsel made a strategic decision not to call somebody they knew to be an eyewitness to what happened in the mornings because he might have been a hostile witness. He might have lied. I understand that. But nevertheless, what Mr. Book said to the officer and placed in an affidavit that he would corroborate that the defendant did not molest her son while he was there, that sounds pretty material to me.
He could not say what happened before he was there,
Absolutely.
after he was there.
Absolutely right. And neither of the live-in boyfriends could apparently testify about what happened when the family was living with the grandparents.
Absolutely.
I understand that. But it still does cover, theoretically, some period of time when as the son testified, these sexual assaults happened continuously every morning, it would cover some period of that time, would it not?
If we take Dennis Book's testimony as true, yes. It would cover
Okay,
part
so
of that
why
time.
do you really argue that that's not material in any way to advance the defendant's cause?
I believe it's important to look at the context of the claim. We are in a successive motion for relief from judgment, a claim that might garner...
That's why I'm focused on whether this is newly discovered or not.
Yes.
it's been asserted that this newly discovered, because it is arguably a Brady violation. They had the conversation. The officer had the conversation with Book. He said, I would have testified honestly. I didn't see it, and I would have reported it. Does that make it newly discovered? And if not, why?
It is not newly discovered because they had knowledge of him. The fact whether
Counsel, they
he-
had
but-
knowledge of him, but they didn't have knowledge of what he was going to say. Don't you see a distinction there?
I do, Your Honor, but using due diligence, they could
Due
have-
diligence.
but-
How do you use due diligence? I have a question, counsel. Due diligence. Would it be, they attempted to approach the witness, they attempted to talk to the witness wouldn't speak to them. Would it be your argument that a defense counsel should call a witness and find out at trial what the witness is ultimately going to say?
Defense counsel said even if that were true, he still might not have called him because that would
Is
not
it
be-
your position that a defense counsel is supposed to call a witness who will not speak to them before the trial, put them on the stand, and find out at the trial what they're going to say? Forget what the truth is. The fact that this is an individual who said what he said prior, wouldn't talk to them, seemed adverse, tells the police detective that he would have testified that he never saw anything happen, that nothing happened. He tells that to the police detective. Under Brady, that is the absolute definition of a Brady claim. Explain how I'm wrong.
Your Honor, with subsumed in the suppression requirement of the Brady claim is a knowledge. When the defendant has knowledge of something, how can it be hidden? How can it be suppressed?
But counsel, the defendant here, the allegation is that the defendant has knowledge of who the witness is, but the defendant doesn't have knowledge of what the witness told the police, right? So isn't the Brady evidence the evidence that the witness went to the police and said she never did this?
No, Your Honor, we believe the
The
evidence
witness itself is the evidence?
his knowledge, what he saw or did not see
But
when he was
evidence is testimony, not knowledge, right?
there. Right.
Okay,
Absolutely.
so a man gives his evidence by testifying, not by existing. So
Right.
how is the witness evidence?
What he had to say in his testimony was the evidence. They did not want to take the risk of calling him and what he could say.
So, okay, so that's
So
fine. So
they
now,
chose.
what I'm wondering about is, I think there's a divide here, and maybe this is the question. Are any Brady claims based on new evidence? Or are only Crest-type new evidence claims based on new evidence? I'm trying to figure out what 6502G means.
6502G means that we need newly discovered evidence to present the claim, and CRESS is the vehicle to determine whether or not a defendant meets that requirement.
Okay, so let's say that a majority of this court disagrees that the Crest standard maps onto 6502G. I don't know whether that's true or not, but if that is true. If that's true, if there's no Crest barrier at 6502G, are we over the hurdle of 6502G?
If there is no CRESS barrier,
If there
Right.
isn't a due diligence, let's start there. Let's say, and I don't see a diligence requirement in here. So if it is wrong to say that in establishing that there is a new evidence, that's the wrong, yeah, right, new evidence, that there isn't a diligence requirement, what is left?
well, first of all, in 6.502A, the court rule does state that defendants should bring their claims with diligence. But if there is no diligence requirement and we're just looking at
Yeah.
whether new evidence has been presented,
Right.
and Brady evidence, as Tim Buffman argued in our amicus brief, can be a type of new evidence.
Isn't it always new evidence? Isn't a Brady claim by definition a claim based on isn't it a motion based on a claim of new evidence?
It is a type of new evidence claims, absolutely, because it's assuming that evidence was suppressed, the defendant could not have known about it, absolutely.
Is it also a claim that's predicated on something other than a constitutional violation? We have in this case an alleged Brady violation. We've had in other cases ineffective assistance at issue. Is that what always characterizes Kress, that it does involve newly discovered evidence and doesn't involve a constitutional violation?
It doesn't necessarily have to involve a constitutional violation, absolutely not. But here we need newly discovered evidence to first even file the successive motion and then have the claims heard under 6.508D3.
Why would you have to go through the Kress obstacle course if you can go through 6.502 where there's a constitutional violation?
Because, Your Honor, I am certain that is the procedure that this court has established, that there must be newly discovered evidence pursuant to 6.502G2.
I thought there was some uncertainty exactly as to how Kress and 6.502 and 6.508 mesh. Am I wrong about that?
I am advocating that Kress is the definition that the court should apply, as it is the test that the court has used.
I understand that, but there is some uncertainty until we accept that argument. Is that fair to say?
That is fair to say, Your Honor.
Let me recur to the question, make sure I understand it. Is a Brady violation always synonymous with newly discovered evidence, as that term is typically employed outside the Brady context?
I don't know that it always is. It can be, certainly. I don't think
It can
I'd
be, but need to be. Well, in what way is it that you're contending that the awareness of Book's willingness to testify truthfully isn't newly discovered evidence within the meaning of this rule?
Because to presume that someone would lie under oath is quite a presumption.
Your voice?
I'm sorry, Your Honor. I don't think we can make that presumption that Book, had he been called to testify, had he been subpoenaed.
It was pretty surly, wasn't it? This was apparently a bad breakup. Both parties knew that. But is his willingness to testify honestly what makes his testimony newly discovered?
No, Your Honor, I don't believe so.
Do you have any case law that supports that?
Not at the top of my, not right.
So can I give you a hypothetical?
Let me just...
Oh, go ahead, I'm sorry.
Are you familiar with Terrell?
Yes, Your Honor.
Doesn't it say a witness's shifting desire to testify truthfully does not make that witness's testimony newly discovered evidence?
Yes, Your Honor. That
Are you familiar with the Sixth Circuit case of Glover? United States versus Glover?
I'm sorry, Your Honor, I'm not.
Pity. You may proceed.
Can I ask you a question? So let's say that we have a crime. We have two guys, they stand on a street corner, A and B, Smith and Jones. Smith commits the crime. Jones did not. There's a witness, and the witness goes to the police, and the witness says, you arrested the wrong guy. You arrested Smith, but it was Jones. Is that Brady evidence? The witness goes to the police. The witness says, you arrested the wrong guy. I was there. I saw it. It was Smith. I'm sorry, it was Jones, not Smith. You arrested the wrong guy.
If it was suppressed.
Okay, so then it would be Brady evidence. The defendant has already filed a 6500 motion before that evidence comes to light. Can they now bring a second 6500 motion under 6.502G? Is that newly discovered evidence?
If they have newly discovered
Well,
evidence.
I'm
yes, they
asking
can.
whether the statement, when the witness goes to the police and says, you arrested the wrong guy, I was there, I saw what took place, you arrested the wrong guy, it was the other guy. That comes to light after the defendant has filed the first 6,500. Does that meet the definition of newly discovered evidence? In order to get over 6.502G, then we can talk about 6.508 later, but just to get over 6.502G.
Is it hard for you to acknowledge the sky is blue here? It's
No, Your
unknown
Honor.
to the defendant entirely?
No, Your Honor, of course not. If it's unknown, but if it's suppressed, for Brady, it would also have to be suppressed.
But it would be a
Absolutely.
Brady violation, and it would be conventionally newly discovered, because you didn't know there was a witness who saw the crime. Right?
So now, I just want to know, what if I knew that if the chief is right here, what if I know that there's a witness who saw the crime, but I'm worried that the witness won't be able to tell between Smith and Jones? So maybe they're both African American and the witness is white, and the defense counsel is worried that the witness won't be able to tell the difference. Now that might or might not be a good assumption, but they're worried about that. Is it newly discovered evidence then, even if you know there's a witness? I'm just wondering how the Brady information that was newly discovered evidence in my first hypothetical is not newly discovered evidence in my second hypothetical.
I understand, Your Honor. I see also that I'm nearing my time, and I would
Whoa,
like to
whoa.
allow the Solicitor General some
I'd like an
time.
answer to the question.
If you have one.
Could you repeat the question, please?
So I'm wondering whether the character of evidence changes depending on whether we know that the witness exists. Is it newly discovered when we don't know that a witness exists, but it's not newly discovered once we know that a witness exists?
The character of the evidence, whether someone would be a favorable or unfavorable witness, does not change whether it's discovered or not. I think that is the easiest answer I can come up with, and I would,
Counsel,
if you
this
would
is
allow
a-
me to
Counsel, this
see
is...
the remainder of my time.
Well,
as
actually, I'm going to
to-
ask you a question. And the reason I'm a little intense is because this is a 50-year prison sentence that this woman is facing. This is her life. It's 50 years.
Yes.
So I'm going to ask you a question. You actually, and I just want to hear your perspective on this. When we get to the materiality question, and we're using an abusive discretion standard, it's a relatively low standard. Would you not admit in terms of giving that discretion to the trial court judge?
We do give discretion, absolutely, to the trial court's findings, but in this case, the trial court did not take all of the evidence into consideration, and we are asserting
Well, the
that-
evidence that we're looking at here in terms of this situation is you're looking at a witness who's basically saying that he never saw any such abuse during the timeline that the prosecution argued. And it's your actual contention. I just want to understand if this is actually your contention, that the jury verdict, this would not affect the confidence of the jury verdict, knowing that there was a witness who could testify that this did not happen under their watch when the timeline that was argued that it happened under his watch?
Yes, because...
You don't think that would have any impact on the jury? It wouldn't be any, that wouldn't affect the confidence of their decision?
No, Your Honor, it would not.
It would not affect their confidence of the decision?
No, because it would be contrary to the testimony that was presented and of the same type that was presented by Stephen Way. Therefore, it would be cumulative. Thank you.
Good morning, Mr. Chief Justice, and may it please the Court. Aaron Lindstrom for the Attorney General. I'd like to start with the question that Chief Justice was asking about whether it's newly discovered under 502G. And I think the distinction is apparent in the language of the statute. It's a claim of new evidence, not new evidence of a claim, right? When opposing counsel stood up here, he admitted he had new evidence of a Brady claim, which is different from a claim of new evidence. To be a claim of new evidence, there has to be some actual new evidence that goes to whether or not the person was guilty or innocent.
So-
Whether
Are you under a free fire zone?
No,
I don't think I have one
Okay,
here.
good. So here's what I'm trying to understand. Is it your position that the right reading of 6.502G is that there are, with respect to the motions based on a claim of new evidence, that the only kind of claim, substantive claim, that you could present would be a new evidence claim subject to Kress? So a Brady claim could never clear that hurdle.
No, I think some Brady claims
Okay, so
could clear that
which
hurdle.
ones?
So if it was a Brady claim where the evidence that was suppressed, and Brady itself talks about evidence that's material to the guilt or innocence.
Yeah.
So it has to be evidence that's material to the guilt or innocence. And if it's new evidence of that, as opposed to here, it's just new evidence of a strategic consideration as to whether or not to call the person. Right? The underlying evidence as to whether or not she was guilty or innocent, she knew that at the time.
Right,
Under-
she knew.
Right.
She knew, I mean, we're assuming here.
Correct.
She knew or she believed she didn't do it. But what she doesn't know is what the witness perceived. She knows the truth. She doesn't know if the witness perceived the truth.
So I guess you're saying she doesn't know if I'm not sure how the witness could not perceive the truth under her theory that this gentleman was there all the time and would have seen it happen. So it's hard, I'm not sure how to separate the two. It's really just about whether or not he'd be willing
Okay,
to testify.
so maybe that's this case. But what about the case of Smith and Jones standing on the corner? And I'm worried about whether the witness will accurately perceive the truth. I'm A, Viviano is B. He did it. Of course, I did not. But I know there's
I know
a
he did
witness. I know the truth. The truth is I didn't do it. But what I'm worried about is I don't know what the witness's perception of the truth is. But the police know what the witness's perception of the truth is. The witness's perception of the truth is Viviano for sure, not Larson.
So in an instance where the person is going to be
Now,
testifying.
maybe that's not this case, but
No, it's-
help me get there.
Sure, I'd like to, it's not this case. You're not talking about a fleeting, somebody standing in a corner looking at a traffic accident. We're talking about her testimony, if true, would be that this is the course of a year. So if he's going to testify, she should know what the content of his testimony is going to be. I mean, that's the whole point of bringing him
Unless
out
he's
now.
going to lie.
I'm sorry?
Unless he'll lie.
Unless he'll lie, right. The fact that he might lie in the stand, it goes to whether it would be a strategic call, whether or not to call him. And that doesn't go to whether the person is guilty or innocent, which is what Brady, for example, is focused on. It goes to whether or not this person is going to testify. And we have many mechanisms in our system to make sure the person testifies truthfully. We've got the perjury.
I am trying, like Justice Larson, to figure out what the prism is here. If I'm accused of vehicular homicide, and it turns on whether I had the right-of-way, the red light or green light, and there are two witnesses who saw the accident, are they newly discovered if I don't know whether they saw the light that was for me was red or green?
I would say they are not newly discovered. If you knew at the time of trial that they were saying that their testimony would be available, it's like saying a videotape is newly discovered if I haven't watched it, right? If there's a videotape that was filming the trailer for the entire year, and then she knew that the videotape was there, but she didn't watch it and didn't think it would be accurate for some reason, then she's saying that videotape is new evidence. And I don't see it. That's essentially what this case is like.
But if the cops had the videotape all along and she never had access to the videotape, then you would concede that it was
Right.
new evidence.
In that instance, there would have been suppression. It would be evidence that was not discovered or could have been discovered by her.
No, you're making a Brady analysis. I'm just trying to understand conventionally here.
Right,
If she didn't know there was a video,
right.
and that was known to the police, the later discovery that there was a video of the interior of her trailer is newly discovered. She
Correct.
didn't know it.
Right.
If she installed the camera and had the video going, then the fact that she didn't review the tape doesn't mean that the fact of this film is not newly discovered evidence.
I agree. I think that's the,
And I'm trying to figure out
But
why
she
a
can
live-in...
only review the tape by playing it in court before the jury.
It's not newly discovered to her. She didn't review it. I'm thinking a live-in
No,
boyfriend
but she
is
doesn't
like
have a
that.
chance to review it. She can't play the DVD in her living room and then put it on in front of the jury. Because that's our circumstance, right? You can't, she doesn't have a grand jury subpoena power to have an investigative power to interview the witness. She has no way to make him talk. I suppose I should talk to you and not to the chief.
I thought you were talking to him.
during part of it, Your Honor. So I think I think that analysis you're going through shows that there are strategic decisions to be made about whether or not you would want to play that tape at the trial.
Right.
But it doesn't show it's newly discovered. It shows that even though I knew it was there, I thought it was too big of a risk strategically to play it. So the evidence is still there. And that's what here there's no uncertainty in her mind about what the video shows. This case is where if you accept her version of events, which is contrary to what the jury found, then she's saying that he was there, that he saw it, and he knows the truth. So you don't have to worry about what the video.
Let me just see if I get this right. So it is the government's position that if this were a videotape, that she cannot view in advance. So she doesn't know what's on the videotape. She has to just put it on in front of the jury. Even though the government knows what's on the videotape. The government knows that the videotape shows that she didn't do it. The government, it's not new evidence when she finds out that the government knew all along that the videotape shows she didn't commit the crime?
So I'm not sure how the evidence could say, in the videotape example, I'm not sure how it could show something other than the truth in her circumstance. So I don't see why in the videotape example there would be any difficulty with putting it on. But again, I think the basic point, before you're thinking about even the Brady point, is the point that's been raised earlier, that this is not a claim of new evidence. As opposing counsel said, it's just new evidence of a Brady claim about evidence that they were already aware of.
Is it wrong to think of it as new impeachment evidence?
I think it's wrong to think of it as
would qualify under Brady, right?
I think it's wrong to think of it as impeachment evidence because impeachment evidence is useful to attack a prosecution witness, show that the prosecution witness has been undermined. But if you don't put a witness on, then by definition, evidence about your own person would be favorable to you. Any impeachment of that person wouldn't be...
Well, impeachment evidence could be of any witness, right? First of all, not just on one side or the other.
None of the Brady cases I'm aware of in the United States Supreme Court have addressed impeachment evidence in the context of somebody the defense could have called but didn't. They've all advanced circumstances where it's a prosecution witness, and so it would undermine the prosecution's case. So that's true in Brady, Giglio, Strickler, it's not Brady, Bagley. All of those cases, they went with the other scenario. So I don't think that it does apply in this case, because if you think about how to try to apply the prejudice analysis in that context, you're not comparing it to what actually happened at trial. You have to compare it to what would have happened at some hypothetical trial if this person had testified, and then you had this Brady evidence that you would have then been able to use or not. So I
find it a little intriguing because you keep referring to it as a strategic call, and I wonder if that impeachment evidence would have an impact on the strategic call that you referred to, whether to call the witness or not.
Right. I think the fact that it's strategic in this case is enough to decide it, because this is not a case where she had this person put on and then she could have used the evidence to impeach him. Didn't put the person on at all. And then it's contingent.
The counsel testified about why that was done, right?
Correct. Affirmatively said we thought he'd be a hostile witness, weren't sure he'd tell the truth on the stand.
But later on said if I had this impeachment evidence, I would have called the witness, right?
No, the strongest statement in Swain's brief about this point is, if I'd known about this is page 11 of Swain's brief, I would have investigated, and I probably would have called, I think didn't actually say would have called. So in determining whether this would have changed the outcome of trial, it's contingent in several ways. It's contingent on actually putting the person on, then the person actually lying, and then you putting it on, and contingent even before that on whether or not this person would have been investigated and called. So I'm not sure when it's contingent 4 times like that, how you could say it would be probable to cause a different outcome at the trial.
Can I Oh, go ahead.
No, I was calling time, so go ahead.
Oh,
and
I'm
ask your
sorry.
question.
I just want to follow up on this impeachment evidence point. So I think it's Bagley, but forgive me if I'm wrong, the case that decides that impeachment evidence is Brady evidence. So in that case, the impeachment evidence was that the defendant had made, that the witness had made a deal with the government.
Right.
And that was impeachment evidence that the government had to turn over under Brady. But your view seems to be that's not new evidence. It wouldn't satisfy the new evidence standard because the defendant herself could have asked the government witness, did you make a deal with the government? And then he would have had to tell the truth.
It's different in one respect that
Why?
the witness is not even called in our case. So again, we're talking about.
No, I understand, but the question here is about, strategy and what kind of questions you're going to ask, right? And so you seem to think that in the impeachment case, it's not Brady evidence or it's not newly discovered evidence, the fact that the government's witness has made a deal with the government, because, of course, the defendant could have just asked, hey, did you make a deal with the government?
I'm not saying that in the context of Brady, when the government witness testified, and then the new evidence would have allowed you to cross-examine, sure the government witness is lying, and that is something that goes to whether or not you're guilty or innocent. But I think it's stretching it too far to say, and none of the cases that I'm aware of have gone to where you didn't call the witness and you made that decision for a strategic purpose, and then hypothetically, if you could have called that witness, we have this other hypothetical trial, it would have been Brady evidence in that trial. Because in that circumstance, it would have helped you impeach that person that you didn't call.
Yeah, maybe.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. The willingness of witnesses that are already known to the defendant to testify truthfully has always been found to be new evidence that can support a Brady claim. That was true in Kyle's. By the way, I did look up in Kyle's. Beanie was known to the defense. In fact, Beanie did not testify, but he was actually brought in so that a witness could look at him and exclude Beanie as a possible suspect. So the defense in Kyle's made a strategic decision not to call Beanie because they did not know about all of the statements that he had made to the police and prosecution that were not turned over to the defense. The videotape example is a little bit different in this situation because by hypothesis, you will probably know what's on the videotape, but you don't know what a witness is going to say until you get a statement from the witness that's been given to the police and prosecution saying, here's the truth. And that's true in all of these cases, Kyle's, Brady, the Tavera case from the Sixth Circuit. All these cases, the defense doesn't know what the witness, they know about the witness, but they don't know what the witness is going to say.
I'm trying to understand something.
Yeah.
More commonplace situation which people are attempting to get a different outcome in a successive motion is to say there's an alibi witness. And I know, as the defendant, I know the alibi witness because he was with me. And then the alibi witness says, yeah, I would have supported him at trial. Does that make the alibi witness newly discovered?
No, Your Honor, but if
Why?
if the alibi witness is given a police statement unknown to the defense saying, I was with the defendant at the time, and that information is not turned over, then we have a potential Brady claim that still has to be examined for
I
material.
understand, but I'm trying to understand. I know you'd like to have a seamless connection between Brady violations and newly discovered. I'm still insisting on analyzing separately the question of what constitutes, traditionally speaking, newly discovered evidence. And traditionally, as I understand it, just the fact that if I knew that there was an alibi witness and didn't call them, I can't later in a successive motion say, there's newly discovered evidence, this witness was in my house.
Right, but
You agree with that? That's not newly discovered.
I do, but everything changes when it turns out that that witness has gone to the police, or the police has gone to him, as in this case,
Okay.
and made a statement.
Why? Why does it change?
Because then if the defense has made a decision not to call this witness based on the belief that the witness will not be helpful, and it turns out that that's not true, that's a classic Brady violation. The courts have over and over again held that that is a Brady violation. Brady itself is based on that premise. As a matter of federalism, and I refer you to the...
Can I just ask one question? Is it your position that all Brady claims are claims based on newly discovered evidence?
You know, that is
6.502G.
That is the claim that is made actually in the Prosecuting Attorneys Association amicus brief. I have not been able to work that one through myself. They may be. I think Brady claims not discovered until after the prior motion do automatically satisfy 6.502.
I guess that's what I meant.
But I'm not sure about the absolute nature of the Prosecuting Attorneys Association brief. The former prosecutor's brief, I just want to point to that because it answers the point of, as a matter of federalism, I can't believe that this court drafted 6502G to say our courthouse doors are not open to new evidence of Brady violations that weren't discovered in time for the first motion. Take them to federal court.
That's a little broader than I'm suggesting. I'm suggesting some Brady violations actually involve newly discovered evidence in the classical sense. So it is not necessarily for a Brady violation that the evidence be newly discovered. It's just suppressed. So I think there's a range of Brady violations that might satisfy our newly discovered evidence rule and some that might not.
Understood, but I think this court would have drafted 6502G with the intent that Michigan courts get the first bite at the apple to decide whether there is a true Brady claim. If I may say one last thing, if I can refer the court to...
Mr. Moran, can I ask you one thing, please?
Sure.
I think the advocacy has been very fine here, and I think the judicial exchange has been a very thoughtful one. But I guess I'd like to ask you, you've been heavily invested in these kinds of cases over the years now. Is this the kind of exchange, thoughtful as it has been, that you would like to see in cases in which you believe there's actual innocence? That, in other words, is the 1,000-pound gorilla that's kind of standing behind the debate and the discussions and the analysis of the law that we're engaged in. I, for example, and I haven't come to any conclusions yet, but I don't want to distort traditional understandings of relief from judgment, concepts like good cause and prejudice and new evidence. At the same time, it's pretty hard for a judge to sit still when there are arguments of actual innocence that are settling in the background. My question to you is this, it's a fairly straightforward one, I think. Is this the kind of environment in which we should be dealing with these cases, or can an argument be made that it would be better to do so under some of the provisions that have been discussed in your briefs, like MCR 7.316, MCL 770.1, or even possibly creating a constitutional due process right of some sort not to be incarcerated when one is actually innocent? I'm not entirely comfortable with that kind of expansive discretion being conferred upon judges either, but what are your thoughts? We've gone through this process once or twice before, and I think as a responsible court, and none of us really being enthusiastic about actually innocent people being incarcerated, we'll probably look at cases like this in the future as well. What is the best environment, legal environment, in your opinion, in which to consider these kinds of matters?
Thank you, Justice Markman. You'll notice that my entire argument today has been based on 6502, 6508. I am certainly not conceding any of the other arguments we made. The court asked us to brief all of the possible alternative ways to get there. We believe Ms. Swain wins under 6502, 6508 as drafted, but I certainly accept and promote the idea that there is a background principle that actual innocence matters, and that actual innocence should inform the way that this court interprets these various provisions, just as the federal courts do in the habeas analogy, that actual innocence gets you past procedural problems of all sorts, statute of limitations, procedural default, that you could not otherwise get through without a strong showing of actual innocence. Whatever the standard of actual innocence this court ultimately adopts, and I don't think you need this case to do it. I think you can wait for another one of our cases down the pike to make that determination. But whatever standard this court settles on for actual innocence that would waive procedural defaults if they're present, I believe Ms. Swain meets it, and I think Judge Sint has found it, and I think this court should defer to Judge Sint's finding on that point.
But of course, we wouldn't have to reach out to find any sort of Herrera actual innocence claim in order to rule for your client.
That's my
correct?
position. My position is that we win under the court rules as written, but if there is any problem in the court rules as written, this court should read those rules in the same spirit the federal courts read habeas corpus and allow actual innocence to excuse any procedural problems that this court perceives.
Thank you very much. The case is submitted. We will take a lunch break and return at 1 o'clock.
Thank you, Your Honor.